Good morning, Mr. Graham. It's fine, those water containers are difficult to open.
Yes.
You need a PhD to figure it out.
Thank you. May it please the Court, my name is Stuart Graham, counsel for the defendant Lewis Mathews. I assume, of course, that the Court is familiar with the facts, so otherwise I'll proceed to the argument. On Mr. Mathews' behalf, I'd like to address two issues this morning. One is the presentation of inconclusive DNA evidence. The second is the impairment of the integrity of the grand jury. And he contends his counsel was ineffective with regard to both of those issues. The Commonwealth presented some significant evidence of blood taken from the defendant's fingertips, hands, and clothing. All that evidence was admitted without objection, and all of that evidence was testified by the DNA expert to be inconclusive.
Mr. Graham, you rely, and it's definitely in the case, on Kernan, I think,
Yes, ma'am.
which was a case decided at a time, I take it, 99, I think? Anyway, before DNA evidence was being admitted. I'm wondering if there are subsequent cases, because I didn't see any cited, and I didn't see any cited in the Commonwealth's brief, where this issue of inconclusive evidence has come up, other than that one line in that one footnote.
No, Your Honor. In fact, I did shepherdize Kernan. Had I found a case, I would have given it to you, but I did not. And Kernan was the case in which the Court did discuss the admissibility of DNA evidence, both conclusive and negative. And in the footnote, it did address this kind of evidence and stated that
I guess I'm just, and I could be wrong, but my memory as a trial judge is that there were certainly cases where inconclusive results were testified to.
I would agree with Your Honor on that. There are a number of trials where inconclusive DNA evidence is admitted, often without objection by defense counsel.
As here.
And the point that we're making here is, based upon Kernan and based upon the speculative nature of inconclusive DNA evidence, the Court was correct when it said it was inadmissible. And it's inadmissible because the character of DNA evidence is such that it will affect the judgment of the jury. In this case, the inference that the Commonwealth wanted the jury to draw was that since the victim was not excluded by DNA evidence, they could therefore draw the inference from the DNA evidence that he was included. In fact, the prosecutor stated in closing arguments, and I'll quote this, that the DNA evidence did not exclude the victim as potential contributor to the DNA on the defendant's hands, but it was not an exclusion. And it simply said...
You finish. I apologize.
Okay.
Go ahead.
It simply said there wasn't enough there to confirm that, but it was not an exclusion. Remember that carefully during your deliberations, because that is important. That is, what the prosecutor was doing was focusing the jury on the confirmatory power of DNA evidence and saying, in this case, it didn't exclude him. Therefore, you can infer from this evidence that it included him.
But wasn't your, the defendant's point, look at all this blood everywhere, they tested it, and except for what was on the, maybe on the defendant's hands, is that right? I mean, there was none of the blood on things other than him were his. So, I mean, wasn't that beneficial to your client?
It was what would have been beneficial for them not to have mentioned the DNA results, because it's not beneficial when you wrap inconclusive speculative evidence within the context of scientific evidence and clothe it with a confirmatory power that it doesn't have.
But didn't defense counsel in his closing make an affirmative statement that the victim's DNA was not found on the defendant? Didn't he state it in the positive?
I apologize, Your Honor. I don't think that's what he said. I think what he said was they did not include him, and that he was trying to focus on the fact that there was nothing to link the defendant to this crime, that the victim's blood, that what was found in Mr. Mathews' hands was Mr. Mathews' blood. That's the point he was making. Now, he had to try to address this evidence, A, because he failed to object to it as he should have, but B, there was evidence that was presented, and it was presented precisely for that inference, that you can infer from this evidence that the victim's blood was included, and that's speculative evidence, and it's improper to ask a jury to draw an inference from speculative evidence. The evidence should not have been admitted.
But
Yes, Your Honor.
I guess I see the point about drawing an inference from speculative evidence, but if you've got the blood, and it seems to me the Commonwealth is going to be entitled to say we tested it, because otherwise they've got a Bowden problem big time, right?
I don't think so.
Why not?
Because in this case, I mean, what they argued in the brief was that the defendant would have argued failure to test.
Yeah.
But the defendant couldn't argue failure to test because the
But
defendant
the jury
knew.
would have thought failure to test, wouldn't it?
Had that been a real issue, they could have asked for a jury instruction to prevent the jury from drawing improper inferences. There are a number of ways you can deal with that, but you don't put in impermissible speculative evidence and say we put that in because the jury might draw an adverse inference if we don't. This evidence should never have been there. And it should have been kept out, and you can deal with that in other ways. But the defense counsel surely could not have got up and argued that the Commonwealth did not test, because he knew that the Commonwealth did test, and he was ethically obligated not to mislead the jury. So this could have been dealt with in a number of ways.
Well, I take it that, at least as I read your brief, Mr. Graham, is that there was DNA testing, on the fingernails and the shirt, under the fingernails and so on and so forth, and I take it that excluded the victim, correct?
No, it was inconclusive.
All of it?
The fingernails, the
stick
blood
was
on
the
the
only.
hands, under the fingernails, and on the shorts was positive for the defendant. It was his blood.
Right.
But it was inconclusive as to anyone else.
Okay.
There was one piece of something that was negative for the defendant.
That was the murder weapon.
The stick.
Yeah, the stick that was found at the scene.
Negative for
that
the
was
defendant.
negative for the defendant.
And
Excluded
positive
him.
for the
Positive for the victim.
When you say that the blood was identified the defendant as a contributor, the DNA testing identified the defendant as a contributor to the blood that was on his own clothing, and it was inconclusive as to others. Were these mixed samples?
It seems that there was some other contributor,
Okay.
but there was the testimony. It just wasn't clear what that was. It could have been contaminated. It could have come. Part of it was, say, from his hands. He touched other people, shook hands. There's a variety of ways other DNA can get mixed with that. So you can't infer from that it's the victim's, but that's precisely the inference that the Commonwealth asked the jury to draw. And that's what's wrong with it. It's just purely speculative. And when you wrap speculative evidence like DNA evidence, in the aura of science, that impacts the jury. We've talked about the CSI effect. The jury wants and believes in the power of science to solve crimes.
Well, that's why the Commonwealth wanted to put it in.
That's why the Commonwealth wanted to put it in.
What's
because-
wrong with that?
And one might argue had to put it in.
Well, I think we've addressed, I don't think they
Yeah,
have.
no,
put-
all right,
They
but-
shouldn't have put it in. The court said they shouldn't have. There's no doubt the Commonwealth wants to put in and should put in evidence of inclusion and evidence of exclusion. But as this court said, inconclusive DNA results is so speculative and so prejudicial because of the effect it'll have on a jury. That's inadmissible. I'm sorry, did you have a question?
No, I'm sort of thinking to myself, it seems to me it may be inadmissible for certain purposes. It may be inadmissible for purposes of arguing or even suggesting that the defendant was not excluded, and therefore it's in his blood. I think we really have to read the closing arguments very closely to see exactly what was argued by the defense counsel and whether the prosecutor's response was a fair retort to what the defense was arguing.
Yes, I understand that point. I believe the Commonwealth argued that, and I would reply to that. The problem here began with the initial introduction of the evidence and the failure of defense counsel to object to it. That was ineffective assistance of defense counsel by failing to object and keeping that evidence out. Now the evidence is in, and it should not have been in. The question is, what then is done with it? Defense counsel, having failed to object, has to say something. But I think he merely tried to argue that, tried to diminish the impact that would have. But the prosecutor directly asked the jury to draw that improper influence. Now, there are a number of ways you could respond to the defense counsel's argument, but you don't respond by an improper argument of your own and asking a jury to draw an improper inference from speculative evidence that because he's not excluded, he's included, and to point the jury to the confirmatory power of DNA when there is none in this situation. So we believe that the impact of that kind of evidence in a case like this, where there was no other direct evidence linking the defendant to the crime, there was no forensic evidence linking the defendant to the crime, there was minimal circumstantial evidence. I think other than the blood, there was some testimony by some witnesses who heard some arguments between two men.
Well, that was pretty powerful evidence, wasn't it?
Well, in neither of those situations was the defendant identified.
But I mean, if I recall correctly, there's the sister of the victim.
I'm sorry, Your Honor, I was talking about the two witnesses hearing an argument on the street.
Oh, okay, okay.
On those, there were two separate incidents. Neither of them identified the defendant. With the sister, she said the defendant was there at around 12 o'clock and said, I'm going to kill your brother. You need to help me. You need to do something. According to her, he's asking for help. She didn't believe him. She didn't get up. The problem with that evidence and what weakens it as circumstantial evidence is that the Commonwealth also put on a bartender who had the defendant in the bar with the victim at 12:45.
I understand that.
And the other witness is testifying to their being together at 1 o'clock. He couldn't have been there at 12 o'clock making those statements.
Granted, but there's a series. She wakes up, he's sitting there in the chair, or no, he's opening the door.
He's opening the door to talk
Then
to
she wakes up at 4 in the morning and he's sitting in the chair, and then she wakes up at 6 or something and he's still sitting in the chair, and then he's in the car, and there is quite a bit of evidence that might link him with this crime.
Well, none of that links him to the crime.
But wasn't the bloody shirt worn by the victim behind the chair in which the defendant was sitting, or am I mixing this
No,
up?
there was a shirt worn by the defendant. He'd taken his own shirt off.
Well,
There was a shirt.
Hadn't she given her brother a black shirt as a birthday present or
Right.
something like that?
That's what
Which was found behind the recliner?
That's what I was about to say. There was a shirt that not that the defendant was necessarily, or the victim was wearing, and it wasn't bloody.
All right.
It was just a shirt found.
That she had given
in
him
the
to
chair.
wear that night or something.
I believe so, but there was no
Yeah,
blood
okay,
on that shirt.
So there wasn't blood on that shirt. I misunderstood.
In fact, that confirms the fact that the victim had come there that night, as the defendant said. That corroborates what the defendant's account is. The fact that the defendant is there every time the sister wakes up also puts him in the house and not outside killing someone. So there is no evidence that links this man to this crime.
What about the Sambuca bottle? He bought Sambuca earlier that night. A woman reported that someone threw a bottle at her near her, and the next day they found it was a Sambuca bottle.
Yes, in fact, she identified the victim as the individual who threw that bottle, not the
She
defendant.
said there were two people.
There were two
together.
people, but she couldn't identify who the other
One
one
had a
was.
ponytail. Didn't she give a description that matched the defendant?
I'm trying to get my people correct. She said one was tall with a ponytail, other was just someone of mixed race. That's as close as she ever came to an
The
identification.
tall with a ponytail would be, the defendant had a ponytail, correct?
No, the victim had a
Oh, the
ponytail.
victim, okay, because I did.
That's
oh.
correct. I would like to address briefly the impairment of the integrity of the grand jury. I think this is an important point. Mr. Mathews says that the Commonwealth misrepresented the evidence presented to the grand jury and impaired the integrity in two ways. First is by telling the grand jury that he invoked his right to counsel and to terminate the interview, and second by presenting false or perjured testimony. The first came about when the detective told the jury that Mr. Mathews invoked his right to counsel and refused to speak further to them after being confronted with some potentially inculpatory evidence. He asked them, all right, if it was their self-defense, you need to explain to us what happened. And says at that point he invoked his right to counsel and stopped the interview. In Commonwealth v. Callaghy, the appeals court stated they agree with the trial judge that they strongly disapprove of telling a grand jury that a suspect invokes their right to counsel. Now, that has not directly been held in the Commonwealth. The closest you get to that is perhaps in Freiburg, where this court referred to Calandra in the Supreme Court, saying that obtaining evidence in violation of the Fifth Amendment may not require dismissal. Calandra, in fact, was a Fourth Amendment case. It didn't hold that either. It's never been decided. But even if that were the case, that's not the point we're making. The point we're making is that the Commonwealth took constitutionally protected action, invoking your right to counsel, and transformed it into consciousness of guilt evidence.
I thought the assistant district attorney advised quite to the contrary, that of course that couldn't be used. He had absolutely every right. I mean, wasn't there some cautionary instruction that the assistant district attorney gave after that?
After eliciting the testimony, there was a pro forma statement saying, oh, well, he had a right to do that. That's totally ineffective. If they knew that, he should have prepared his witness. He shouldn't have done it in the first place. You do things like that in order to get it in, and then you get an objection.
Let me ask you this: doesn't the grand jury have a right to ask that question? Well, what did he do after then? Well, I can't tell you. What did he do when you asked him this? I can't tell you that. I mean, doesn't that kind of odd?
Your Honor, we're talking about two separate things. The first, the right to counsel, was not in response to a grand juror's question. That was
but I mean, you're saying that this was totally inappropriate, as opposed to something that probably shouldn't have been said, but the district attorney sort of pointed out that he had a right to do that, and they shouldn't hold that against him.
Well, it shouldn't have been testified to in the first place. Once it's there, you're telling a jury, forget what you heard. It's there for a reason. It's put in for a reason, and it's done often for a reason. That reason is to draw an inference of guilt from the exercise of a constitutional right. That's what's wrong. That's why it impaired the integrity of the grand jury. This is not a situation where competent evidence is obtained in violation of a constitutional right. That's Calandra, the Fourth Amendment case.
You say you have to reverse the convictions because that evidence didn't come in at trial, so it didn't. I mean, in other words, unlike the cases that you cite where you get half the equation with the grand jury and then the jury convicts on the whole equation, you're saying those cases don't work here.
They don't work, and they don't work on the false testimony that comes after this. Obviously, this evidence was not put before a trial jury because Doyle kept it out.
Right.
But it got the indictment. The second part is where the prosecutor used leading questions to get the detective to testify that the swabbing of the defendant's hands was done during the interview. He was presented with results of that evidence, and he terminated the interview. That was done through leading questions from the prosecutor. That was purposeful. That was false testimony. The prosecutor knew it was false. The police officer knew it was false. He was there. Then if you look at the search warrant, the swabbing of the hands was done at 1400 hours, 2 o'clock in the afternoon. The interview was terminated shortly after 11 o'clock in the morning. They knew that was false testimony, and they put it in to get an indictment. Now, it was correctly put in at trial, but the problem is that's blood evidence, and it went in as inconclusive DNA evidence, which shouldn't have been in. So the verdict doesn't immunize retroactively the misconduct in the grand jury for the reasons I've stated. Here is in Odell, the grand jury could have and probably did conclude that since this man exercised his right to counsel and refused to speak after being confronted with some evidence, he's guilty. That's consciousness of guilt. That's an improper inference to draw from the exercise of the constitutional right. Secondly, they would have said he refused to explain why he got blood on his shorts, which is false because he did give an explanation. And he didn't explain how he got blood on his hands. The problem with that is they all knew he wasn't asked how he got blood on his hands during the interview because no one knew it. It happened 3 hours later. So if you put all of this evidence together, the integrity of the grand jury process was impaired because you have the improper inference from a constitutional right, you have the false testimony concerning the swabbing of hands and the presentation of that evidence, and you have the false testimony that he never provided an explanation as to why he was rinsing out his shorts. He did. Now, that latter was presented at trial, but again it was presented with that the blood was inconclusive, again transforming speculative evidence into an inference of guilt that should not have been drawn.
Thank you, Mr. Graham.
Yes, thank you, Your Honor.
Mr. Shack?
Good morning, Your Honors. Thomas Shack, Assistant District Attorney for the Commonwealth. May it please the Court. Your Honors, with regard to the DNA evidence, the suggestion that the inconclusive DNA evidence should not have been admitted at trial, the Commonwealth would suggest is not correct. In so much as inconclusive, the DNA evidence that was inconclusive in this case was not simply presented as just being inconclusive. It was presented as being inconclusive for a reason, and that reason was, in this particular case, that the sample was not sufficient enough to, in fact, give a test.
Mr. Shack, did you think you didn't even need to mention the Kernan case? You don't even cite it.
No, well, Judge, there has been no case law since that point, but with regard to the...
But there's no case law one way or the other, right?
Well, no, Judge. I would suggest there is no case law one way or the other, not that I could find.
But there is that case law.
But that means that's good law.
Yes, Your Honor, but what I'm saying is that this is distinguishable to that particular case in light of the fact that it's not simply just presented as inconclusive. In other words, the answer of law just being presented as, or a result being presented just as inconclusive alone might be problematic. However, when it's presented as inconclusive with a reason for why it's inconclusive, as opposed to just the amorphous suggestion that it's inconclusive, that it's an appropriate...
Yes, but, I mean, I agree with Justice Spina. You have to look at what defense counsel's closing argument, but you say the DNA did not exclude Scott Turner as a possible, not you, but the prosecutor, a potential contributor to the DNA. They, presumably the people who are collecting it, simply said there wasn't enough to confirm that. But it was not an exclusion. And remember carefully during your deliberations, now I'm just quoting from the defense counsel, but in other words, it seems to me that's a little different than saying we don't know one way or the other. You're saying it wasn't an exclusion, and I thought that was the import, that you can have inclusion, you can have exclusion, but you can't have the ambivalence, particularly when you are claiming that it's not an exclusion. The inference is it could be an inclusion, and there's no evidence of that.
Well, Chief Justice, in the transcript, it shows clearly at page 759 in defense counsel's closing, and I'm quoting defense counsel. He says, the defense counsel, she sent it on, meaning the criminologist, sent it on. We received the DNA and the blood on his hands, meaning the defendant's hands, is not poor Mr. Turner's. He doesn't have a connection. There is blood, but it's not Turner's. So he states that clearly in both at that point.
Maybe both are wrong.
Excuse me, Judge?
Maybe both are wrong. Maybe the Commonwealth should have objected.
Perhaps, Judge, but I would suggest to you that in light of the fact that did come out in the absence of an objection, it was certainly reasonable for the prosecutor in this case to respond. And a complete reading of the prosecutor's response to that shows that what the prosecutor was attempting to do was to clarify that particular bit of evidence. And I'm not suggesting that this is, tit for tat, but I would suggest that.
No, he's made a claim. The victim's blood was not on the hands.
Yes, Judge.
And then the Commonwealth gets up and says, you can't conclude that it was an exclusion.
That's correct, Judge. And also, I would suggest to you that the prosecutor, throughout his closing argument, on at least 4 occasions, indicated that, now, ladies and gentlemen, and I'm paraphrasing, your memory dictates what happened here.
No, yes.
And that reiteration, I would suggest.
Mr. Scheck, can I just finish this? Can I just ask you, I understand in the circumstances of this case, it may be that the prosecutor's closing argument was an appropriate response to defense counsel's closing argument. But what should we, as a general matter, say about Kernan?
Well, Your Honor, again, I would suggest that the decision in Kernan was an earlier decision, as was pointed out by the court earlier in this discussion. The state of the evidence was much different at that time when Kernan was decided.
But no, because you can still get inconclusive DNA results, often because the samples are too small.
Yes, Judge.
Right. So we're going to have the same situation. So I'm simply saying, from your point of view, what would be an appropriate rule?
Well, the appropriate rule from the Commonwealth's position would be, one, the admissibility of the inconclusive DNA evidence should be admissible. Again, so long as there is a reasonable explanation for why it is inconclusive, and that's presented to the ultimate trier of the facts. Also, Judge, I would suggest to you that the adverse inference aspect of all of the blood that was collected in this investigation, there was a substantial amount of blood, albeit, when I say a substantial amount of blood, a substantial number of exhibits that were collected. And in that collection, Your Honor, I would suggest that had that one DNA result with the victim's DNA being found on the club or the stick that was apparently used as a weapon in the case, that short of that, it would certainly give the appearance that the Commonwealth did not.
Check. You may be. This may be helpful because then we get to what you can argue from it. But I can't imagine that there's ever inconclusive without an explanation, because the inconclusive. There's always an explanation as to why it's inconclusive.
Well, Judge, you could potentially have an inconclusive result, and again, I'm certainly not a DNA expert, but you certainly could have a DNA result that there was some issue with the test itself, or
there has to be an explanation. So essentially, you're saying it should always come in. Then the question is, what should either side be permitted to argue about it? Well,
and Judge, I would also suggest that in this case, the admissibility of this wasn't objected to. Clearly, because
I'm not talking about this case. I'm trying to think about what's going to happen to all the prosecutors and defense counsel out there in future, not only murder one cases, but any criminal case, because Kernan is pretty clear.
Kernan's a footnote, and it wasn't really the issue in the case, but it is a very clear statement.
Yeah,
certainly it is a clear statement.
What's wrong with it? I mean, what if a defense lawyer says, "Look, I'm not going to argue. I'm not going to make a Bowden argument. You shouldn't be allowed to put this evidence in." What's wrong with that?
Well, I think depending on the trial tactic, defense counsel's trial tactic, I mean, and again, there can be circumstances, certainly, Justice Spina, where you have a situation in which the defense counsel might, if, for instance, in a limited, there might be one blood sample or one particular sample that can be used for DNA and it's inconclusive. Under those circumstances where that's the single piece of evidence, it's possible that defense counsel may say, now wait a minute, that it is inconclusive. We can't tie this to, may not be able to be tied particularly to a particular scene or a particular event or set of events. But in this case, you had so much blood evidence.
But why is it relevant? Let me ask it that way.
For purposes of this?
Yeah.
Well, for purposes of this case, Judge, I would suggest, again, that adverse inference aspect is what makes it relevant. If it would.
But the adverse influence may not be an appropriate influence.
Depending upon the circumstances of each individual
The
case.
defense counsel, he stipulates he's not going to make the argument.
Yes,
He's
Judge.
not going to make the Bowden argument.
Well, in this case, it was beneficial to him to allow the inconclusive evidence in for purposes of
I'm
his
thinking
framing of
thinking about the next case. If you have, what's the relevance of inconclusive DNA evidence in the presence of a stipulation from defense counsel that he will not argue or she will not argue the Bowden case?
Well, Your Honor, I would suggest that again, the stipulation aside, it provides clarity to the trier of the fact.
Why?
Well, it gives him an answer to exactly what happened with the evidence in the case.
But you could deal with that with an instruction, right?
Perhaps.
Yes, but I think what's troubling, at least me, and seems to be troubling some of the other questions is either side, in this case both sides, but in any case, the counsel is asking the jury to draw an inference, which is not a permissible inference.
Well, Chief Justice, do you mean the defense counsel or the prosecutor?
Either way. The inference is either way. I'm not talking about, again, this case, so whether it was a proper response given that the closing had come in and the evidence. So I'm not talking about this case. But just as a general matter, if it's inconclusive, it is not correct to say, from the defense counsel's point of view, that means that there was no evidence that he was there. And it's not correct to say there was no evidence that he wasn't there, the victim's blood.
No, in a vacuum, it's not. But again, when depending upon the type of evidence that comes in that case, and again, depending
It doesn't
upon
depend on that. That's my problem, because there's always an explanation. We lost it, and when we found it, it had been contaminated. Or there's some explanation. There's always an explanation. Typically too small. Either too small or the surface was such that it interfered with it. The normal range. There's always an explanation.
certainly.
So you may want to tell the jury so that they don't wonder. She has all this blood. Why didn't anybody test this? Even if I would say there's a stipulation on the side, the jury is still going to wonder.
Perhaps there should be an instruction with regard to the inconclusive, the nature of inconclusive DNA
Do we know what other
evidence.
states have done on this?
I don't, Your Honor, and I'd be happy to research that and provide a memorandum.
Well, we have very good law clerks.
I'm certain you do.
Are there any?
Can
here?
I,
No,
can
they're
I,
not.
can I switch to the grand jury presentation?
Absolutely, Justice Botsford.
What is the justification for some of the questions that Mr. Graham has raised up? Why was the presenter getting into those things at all?
Well, I don't think that when we're talking about the right to counsel,
Yeah.
Judge, well, with regard to that subject, I would suggest that, again, the presentation to the grand jury is obviously a standard of you're presenting evidence outside of a courtroom, but however with a recording, and in those situations you have multiple witnesses that are really telling a story and telling what their basis is for their investigation. And in this case, with regard to that particular statement, the detective in the matter, there was a Mashpee detective who stated the facts under which the interview ended with the defendant. And immediately the prosecutor, once that was said, immediately he said, well, he's well within his rights to do that to the police officer, and the answer was yes. Obviously, in the give and take that occurs in a grand jury environment, and certainly in this particular grand jury, excuse me for one moment, in this particular grand jury investigation, or presentation, the jurors went on to ask other questions having to do with having the blood on the defendant's hands, and in those circumstances, the prosecutor stopped and indicated that he has a right not to do that, or a right to do this, or a right to do that, so that he's answering the questions. And again, the grand jury, the members of the grand jury are for lack of a better term, the boss of that environment. The prosecutor.
But you're presenting the evidence.
Yes, Your Honor. And we marshal the evidence in such a way so that there's a beginning and an end to the process. And certainly there is advice given and we do give a charge on the issue of the law involved. But when it comes to these issues of fact, the issues of fact should be left for those grand jurors. And again, in the situation when something like that happens, when a situation like a statement like that happens, the best possible thing to do is to give that minor curative, which the prosecutor did. And I would suggest that it was completely appropriate in this case to give that admonition back to the grand jury, and it didn't result in any further questioning on that particular subject.
All right. I had one factual question for you. In your brief on page 5, I wasn't making up about this ponytail.
No, Your Honor, there's a mistake
There is
on
a
page
mistake.
5.
Okay.
And
it should say that it was the
transposed
victim, right?
victim and
Yeah.
defendant. I
Okay.
apologize for
All
that.
right, that's fine. I just want to be sure I wasn't losing my mind.
Now, with regard to that particular issue within the grand jury testimony, I would also suggest to you...
I'm sorry, I just lost you. Which one? Which issue in the grand jury?
Oh, I'm sorry. With regard to the one we were just discussing,
Okay.
Your Honor, the issue of ending the interview, the defendant ending the interview, I would suggest to you that at that time, this was the very end of the second police officer who's testifying before the grand jury. They had heard from the state trooper who was the case officer, and now they're hearing from the detective at the Mashpee who was working in conjunction with the state police at that point. And I would suggest to you that the other amount and significance of the evidence that was presented to the grand jury, even if you found that was impactful in some way on the decision to indict, if you examine all of the other evidence that was presented to the grand jury, it was still significant, a substantial amount of evidence indicating that the defendant was involved in this, and certainly from a probable cause standpoint was involved in this. And also, Your Honors, with regard to the statements that the defendant had said, and Linda Turner's, the victim's sister's statement, how they corroborated each other, how the...
Mr. Shack, we may have to get to that, but the actual question which comes at the end, and this is from the presenting prosecutor, and then at that point did the interview terminate, right? And he says, yeah, the interview terminated. Then the next question is, and incidentally, with respect to requesting a lawyer, that's certainly within his rights not to proceed with the interview and him to request a lawyer. I mean, it's out of the blue, right?
Your Honor, may I ask what page you're on?
32. I mean, the next set of questions, which was in response to a juror's question, I can understand. And I think the prosecutor on page 34. No, it was on page.
Your Honor, may I just briefly bring you back to page 31? There was an answer in the middle of page 31 in which the witness testified that he did not utter anything to us, and it was right after that he said to us that he needed to talk to a lawyer. So I don't think that was...
And then the prosecutor says, strike that. Okay, that's...
And I believe that page 32 is really acting as a curative to that original statement, to make sure that it's clear that you're not to consider that, Judge. I would respectfully suggest that's the answer.
Okay, but because the prosecutor does that again, saying he's got a right to do something or other. He's got a right...
not to say anything.
That's
right. That's the bottom of page 33,
and that's
to say he certainly correct. He doesn't have to say anything.
So you're suggesting that the witness blurted this out?
No, I'm suggesting that when you're dealing with those types of questions, Your Honor, when you have to get to the conclusion of that.
But you said
that interview.
But the prosecutor said strike that.
Yes.
It sounds as though this prosecutor was surprised by the answer.
Well, I'm certainly sure that he was surprised by the answer. However, it's very difficult to tailor an individual's testimony in such a way. I mean, prior to that grand jury presentation.
And preparing a witness for a grand jury is very different than preparing a witness for a trial.
Justice Cordy, absolutely, it is
And maybe
very
what
different.
the prosecutor was doing here was trying to make sure that the grand jury members understood. The witness says something that the prosecutor is surprised by. He says, "It's like that."
Right.
And then viewed another way, in an abundance of caution, he says, now, he's got absolutely every right to do that, doesn't he? In other words, don't draw any negative influence. I understand.
Yes, Your Honor. And as prosecutors, our requirement is, again, to instruct on the law and to advise on the law when appropriate. And I believe the prosecutor did that in this case.
What about what Mr. Graham says is the false testimony about the timing of the swabbing?
Well, Justice Botsford, I would say that the timing of the swabbing, the evidence that is used to suggest that the timing of the swabbing was incorrect was the police report, the information taken from the police report, which is not in the record in this case. It's not a matter of consideration.
But it was used during trial. I understand it's not an exhibit, but it was used during trial, was it not?
Yes, Judge. And that,
it was used for the grand jury.
And it was correctly, and the timing of the test was correctly brought out at trial. Now, with regard to the timing of the test, I would suggest to you that if it's a mistake or if it's an error having to do with the timing of the test, the testimony of the police officer of the state trooper, and then of the police officer, was that the defendant had his hands tested while at Mashpee Police Department. And
that he was asked questions about it during the interview.
That's correct.
And that was not right, was it?
Well, Judge, I believe that there were a number of different, again, with so many blood issues at this point, that they did have the presumptive testing done on many of the issues of the pieces of evidence, including the shorts, including the.
Not his hands, though. Right?
No, well, Judge, I believe his hands were tested, but I don't think that there was a clear timing suggestion at that point of exactly when that testing occurred. I know that there were two different criminologists who testified at trial, both of whom had different assessments of the blood evidence found on the defendant's hands. I know that the first criminologist indicated that there was presumptive testing done on his hands and it tested positive for blood. There was a second, I believe Courtwright was the name of the individual, who said that a further testing couldn't be done based upon the fact that it would have destroyed the evidence.
Why was it even significant to ask about the time when the swabbing occurred?
Well, I don't think it was significant with regard to the timing.
Yes, but he was asked. The question then put to him is, what did he say about it? Right, at the grand jury.
Yes, Judge. What did who say about it? Excuse me, Judge.
The defendant.
Yes, he did. That was presented, and they did have the information at the time of the investigation. Whether he was presented, it's clear from the testimony of the trooper, and it's clear from the other evidence, again, that the testing was done to his hands. If there's a question of timing, there can be a mistake in terms of the timing of the test. The suggestion was that the testing happened back at Mashpee Police Department. I don't think the record is clear with exactly what time that happened, and I would suggest, even if you found that statement were improper, or that there was some issue with motive of why it was done, it was that the police officer had a motive to present that, and that it was false testimony. Again, examining it from the Odell standard of looking at the entire record, it really pales when compared to all that other evidence, including again the statement that he's going to effing kill the victim to his sister.
Thank you, Mr. Shea.
Thank you, Your Honor.
We'll take a short break.
All right.